Okay, I think we can get started now. Thanks everyone for being here this afternoon. I think we probably have some new people in the audience, a new group of speakers. So if those who were here this morning will forgive me, I'm going to just quickly run through some of the guidelines that I've been asked to discuss with you. First of all, very important, when you checked in this morning, you were given a badge and a number. Please keep those with you at all times. And if you leave the room, please take it with you. You'll need it to get back in the room. Most important, remember at the end of the day when you leave to return the badge and number so you can retrieve your ID. Also, there are two exits from the room, one to my left, which is the main entrance to the room, and an exit also to my right. You can exit out of either one. There are restrooms located outside the hearing room to the left and right. We have staff in the hallway who can help escort you anywhere you need to go, or including back to the first floor. This afternoon we will take a mid-afternoon break, probably around 2:30. If you need to move around during the hearing time, please do so quietly. Obviously, if you're a speaker, we are delighted to have you stay with us through the afternoon, but if you need to leave, we understand, and you're free to do so. So just a few guidelines for the speakers. We are going to follow the order of speakers that's set out on the list that was given to you when you entered the room. Every person scheduled to make an oral presentation will be given 5 minutes to present his or her remarks, and the board members will then have an opportunity to pose questions. After that, the speaker will be excused. Every speaker should be ready to proceed in turn, and please move quickly to the podium. We ask that you introduce yourself and indicate who you're representing, if anyone. And if you have someone with you, please feel free to also introduce that person. Your 5 minutes will start after the introductions. Our Deputy Executive Secretary, Gary Shinners, who's seated below me to the right. To my right is our timekeeper. There are lights on the podium to assist you. Your 5 minutes to speak will start, as I said, after the introductions. You'll have the green light will go on at that point. The yellow light will go on, indicating you have 1 minute remaining, and the red light indicates that your time has expired. I think people who are here this morning will be able to say that I'm not a tyrant about the time clock, but it is important that you observe the lights generally so we can try to keep on schedule. If you have a written statement that you wish to put in the record, please give it to our Executive Secretary, Les Heltzer, who is in the anteroom to my left. Please do that before you leave for the day. If my colleagues have additional questions for you based on the written testimony or the written statements that you provide today, we may decide to pose written questions to you. I've asked them to make those available within 7 days, and you will have until the close of the comment period for this rulemaking on August 22nd to supply your written answers. Just a couple final points. Please note the meeting is limited to issues related to the proposed amendments to the board's rules governing our representation case procedures and other proposals for improving representation case procedures. No other issues are to be considered at this meeting today. I want to especially alert our speakers that they should not discuss matters which are currently pending before the board, as there are important rules pertaining to ex-parte communications that we don't want you to violate. So with that, I ask everyone to turn off cell phones or other devices. And unless my colleagues has anything to say at this point, I think we can proceed to call our first witness of the afternoon, Mr. Christopher Koza. Next up will be Andrew Kramer. Mr. Koza? Oh, okay. So Mr. Koza, it seems, is not here. And so we'll start with Andy Kramer. Welcome. Good afternoon.
Good afternoon. Thank you, Chair Liebman, members of the board. Appreciate the opportunity to be here this afternoon. My name is Andy Kramer. I'm a partner in the Washington office of Jones Day. I'm here representing HR Policy Association, which has had a long and sustained interest in the issues being presented by the Notice of Proposed Rulemaking. We appreciate the offer to provide comments today, as well as the written comments, which we will provide in August. While the Notice of Proposed Rulemaking raises a number of questions, I'm going to concentrate on three particular areas that are of importance to the association and its members, but I note it's not to the exclusion of other issues which will be covered in our written comments. At the outset, we believe that by allowing a regional director or a hearing officer to deny an employer or another non-petitioning party the right to a pre-election hearing with respect to the appropriateness of the petitioned unit, if the dispute concerns the eligibility or inclusion of individuals who would constitute less than 20% of the unit, is counter to the direct language of Section 9C of the Act and the requirement of the Act to hold a hearing if there is reasonable cause to believe that a question concerning representation exists. Even more fundamental is the fact that the board, as one of the reasons for this proposed rule, is to try to minimize disputes and litigation. Unfortunately, I think the 20% rule will occasion actually the very opposite. It will, among other things, bring into play issues which are likely to deal with more litigation and not less, including supervisory status issues, which are critically important for the parties to know who might be a supervisor during a campaign. The fact that an arbitrary bright-line rule of 20% might not present that will not help an employer or the petitioning union in terms of knowing who could be an advocate for one or the other during the representation process. If you add to that the removal of discretionary board review, we think the 20% rule is not a proper application of what the board's policies should be in this area. Equally problematic, and maybe even more so in my view, relates to the required filing of statements of position. Time today is far too short to go into all the problems raised, but let me just note a few that I think are important for the board to hopefully consider as you listen today and as you review the written comments. I don't have a problem that an employer should take a position as to whether a unit is appropriate. I think an employer should take a position, one way or another, of saying the unit's not appropriate and present evidence as to why that unit is not appropriate. That's a far cry, however, from requiring an employer to not only offer an alternate unit selection, but one that is most similar to what the parties might agree to. This, to me, is a burden that I think is improper under the statute, but moreover will cause significant issues and problems as you move forward. And some of those problems were even discussed this morning in the sense of preclusion issues, which I will get to in a second, in terms of both preclusion of your right to a hearing initially as well as post-election challenge. Similarly, the information that's required from the employer about alternative units would provide a petitioning union with information it's not seeking or even relevant to its own petition. This information would include full names, work locations, shifts, and job classifications. That goes to the petitioning union. Another list that the regional director gets relates to the Excelsior list issues of email, telephone numbers, home addresses. I have no idea what happens to that list. Numerous concerns, however, in my view, are raised for the need for such information.